take a look at this. In a significant verdict that could now reshape India's legislative process as well, the Supreme Court has established crucial guidelines for resolving disputes between the state governments and the governors over pendency of bills. The April 8, 2025 judgment comes amid the ongoing tussle between Tamil Nadu Governor R.N. Ravi and the DMK government led by Chief Minister M.K. Stalin regarding the clearance of state bills. Now, the bench comprising Justice J.B. Paradiwala and R. Mahadevan ruled that when governors reserve bills for presidential consideration, citing constitutional concerns, the president ought to seek the Supreme Court's advisory opinion under Article 143. Whilst acknowledging that such opinions aren't legally binding, the court emphasized that they carry high persuasive value and that they should ordinarily guide legislative and executive actions. The judgment references the 1978 Special Courts Bill case precedent, highlighting how pre-enactment judicial review can prevent constitutional violations. The bench drew comparative insights from Sri Lanka and Kiribati's constitutional frameworks, where similar mechanisms exist for judicial review of disputed legislation before its enactment. The ruling carefully delineates the court's advisory role, stating it will only opine on the pure constitutional questions, not policy matters. And this landmark decision establishes a structured process for resolving gubernatorial reservations about state legislation whilst maintaining constitutional balance between judiciary, legislature and the executive. The verdict is expected to have far-reaching consequences on center-state relations and the governor's role in India's federal structure, potentially reducing political standoffs over pending legislation. Satish Kumar, advocate at the Madras High Court and of course the Supreme Court as well, joins us on the broadcast here. Advocate, help the viewers understand here the implications. Of course, this is still early doors. We need not jump the gun. But what does this mean for the governor's role? What does this mean for center-state battles? R.N. Ravi versus M.K. Stalin is a flashpoint everybody knows about. But Tamil Nadu is not the only state. We've got several of these other states as well. Over to you. Help the viewers understand the implications and what it might lead to.
According to my understanding of because it's more than 400 pages of judgment, so it requires a lot of time for us also to go through line by line. But however, while seeing the conclusion in the last 20 pages of the entire judgment, I'm able to observe to some extent there are certain things like in para 434. If you see that it gives about the explains what is that Article 200. But while explaining the Article 200, the judgment jumps to 201 also. So when it jumps to 201 about the president's power, then now we advocates are forced to raise our eyebrows on it, because the judgment, the Supreme Court judgment, instead of restricting itself to the present scenario of Tamil Nadu government versus governor, it crosses the border and goes beyond to Article 201 and touching the powers of president also. That creates, it raises our eyebrow a lot, because whether the Supreme Court has got a power to touch the powers of the president also, because as per Article 361, the powers of the Supreme Court is also restricted while touching the powers of the president and also the governor. But in this case, being as a two-member bench, that we have to understand basically. Being as a two-member bench, it is, but I personally feel, I may be wrong or I may be right, but still, because being a Supreme Court, I cannot say anything more on that. It is crossing the borders of the Constitution, because while giving an observation or the personal comments about the governor, I feel it is quite unwarranted, especially giving an opinion about Tamil Nadu governor. I feel those points would have been avoided. And I'm also surprised how the Supreme Court has decided the time frame of 3 months or 1 month for president and the governor. It is highly surprising. Even to give a judgment in this case, the Supreme Court takes more than 2 years to give a judgment. But for a president or a governor to read a law or understanding it, giving an assent is not. It is not. If the powers have been given in 200, that it is not a simple assent, just a signature to make the law. It is also the president, and the president or the governor has got the powers to assess it. So when the powers of assessing a law is given to the governor or to the president, how can you fix the time frame for them 1 month or 3 months. Then the Supreme Court says, if at all it is necessary, the president can even refer to Supreme Court again. Then the matter again comes back to Supreme Court. If that being the case, how the Supreme Court will take? Will the Supreme Court give the same judgment within 1 month or 3 months? These questions are really raising our eyebrow, especially on this point. This present judgment, though it is an historical, no doubt, what my personal suggestion, instead of giving a time frame, the Supreme Court would have referred the matter to the Parliament for giving a proper amendment or maybe a suggestion of amendment in Article 200 and also in 201, instead of giving a time frame like 1 month or 3 months. This is my personal opinion.
All right. Many thanks, Advocate Kumar, because you've really helped us out here. Like I've been mentioning, still early doors. Thanks for your personal opinions as well. And we all know this is the apex court. We have to tread carefully. It is a historical, order nonetheless. But time frame being one of those problems, questions that have now come about. We'll have to wait and find out what will come about once the line-by-line reading and reading in between the lines does take place by the entire lawyer fraternity at large. Many thanks, Mr. Satish Kumar, advocate from Madras High Court and Supreme Court, for helping us out with your insightful insights on this particular story.